Hi there, I'm Del Mackey with the Arrowhead Center, and today we're going to be talking about the IP process at NMSU. So now that you have research with both intellectual and commercial value, what do you need to do? Well, first, you need to fill out an invention disclosure form found on the Arrowhead Center Intellectual Property webpage. We're going to discuss that form at length in the next video, but essentially the form gathers some initial information about the invention and some critical data for a provisional patent application. Once the form's been completed and we receive it, we'll actually start the provisional patent application and then start to do some research of our own. When the provisional patent has been awarded, we will have 1 year to file the utility application. During that year, there's a few things that'll have to happen. We'll have a patentability search done by our outside patent firm to ensure that there will be no issues or hiccups during the patent filing process. This can be a critical part of the process, as many times there will be similarities between previous patents that inventors just aren't aware of, and we have to describe why it's different. We'll also start to look at other items in note, like potential products, marketability factors, and other key parts of that commercial value statement to understand the potentials for the road to licensing. We'll also reach out to the inventor team to meet with them and discuss milestones for moving forward, research that still has to be done, and goals that need to be met in further developing the idea. This is a huge part of that transition process between provisional patent and utility, as the idea, background, science are all things that have to be known in depth for a utility application. The inventors will also receive a declarations and assignments document from the patent firm. This document signs over rights to the patent to Arrowhead Center Inc., who's the patent holding organization within NMSU. Inventors are still listed as the inventing body on the application, but the rights to commercialize the invention will be assigned to Arrowhead. And this is done for a few different reasons. One, it takes the burden off of faculty researchers in having to pay for patenting the invention and paying for maintaining that patent, which can be pricey. Two, NMSU also has to recoup costs associated with that patent process, the resources used, time and effort on the research activities, all of those. And third, this document also establishes the rights of payment for any royalties that come from licensing the invention. The Arrowhead Center is assigned rights on the patent and holds the patent. Generated royalties are split 50-50 between the inventors and NMSU. Also, during that year, typically 3 to 4 months before utility applications due, a convening of the intellectual property and commercialization, or IPAC board, will be called. The IPAC board is comprised of administrators, fellow researchers, and Arrowhead staff, and they decide on whether there's commercial merit in seeking a full utility patent. If the board votes in favor, then we go ahead and file the utility patent application. If they vote against, then the invention will be assigned back to the inventor, and NMSU will relinquish all claims on the invention. At that time, inventors are free to seek their own protections on the invention. And we'll discuss that more in another video. Once a utility application has been filed, it's essentially a game of volleyball. Typically, an examiner from the USPTO will be assigned to the prosecution of the patent, and they'll review the application. They'll do some digging around and a lot of times try to poke holes in the application and reject certain claims. This is fairly standard practice, so there's not much reason for concern during this process if you do get some notices back. And when an examiner rejects claims or requests more information, they'll send a notice to the patent firm. And then they will reach out to the inventors directly, copying Arrowhead on all communications, and we'll work together to try to answer the examiner's questions or to try to counter those claim rejections. This is typically lengthy, though, as most times applications can take 6 to 12 months for an examiner to even be assigned to the case. All we ask is that inventors respond to the patent firm in a timely manner and be open for communications, as those office actions from the USPTO are always time sensitive. If the response isn't received within their window, then they can actually fully reject the application. Once a utility patent has been issued, then the fun game of commercialization activities begin. Though an invention can be licensed at any time, most organizations will wait until a utility patent has been secured, or is pretty far along that process, before optioning a license. Scott's going to discuss the wide world of licensing in another video, but a critical factor to know is that we need your help in licensing. Though we do our best efforts to market the technology, many people might reach out to you directly about the technology, so just keep us in the loop on any of those communications. Also, regular maintenance fees are due on utility patents in order to maintain those protections. When we receive a notice that maintenance fees are upcoming, we'll reach out to the inventors to check on the status of the invention, discuss any strides that have been made, and talk about where the market has moved and where the current state of the art is. If the patent is deemed to no longer be commercially viable, we may reassign and relinquish rights to the inventor at that time, though it's rare to discontinue the maintenance of the patent. If you have any questions on this process, please don't hesitate to contact us, as we would be more than glad to discuss it with you in more detail. Thank you for tuning in, and we will see you next time.